So today we will be continuing our discussions on misconduct by physicians as is defined under chapter 7 of the Indian Medical Council Professional Conduct, Etiquette and Ethics Regulations 2002 made under Indian Medical Council IMC Act 1956. So far we have covered 7 types of misconduct, namely violation of the regulations, non-maintenance of medical records, non-displaying of registration number, adultery or improper conduct, conviction by court of law, sex determination tests, and signing professional certificates, reports and other documents. Today we will be starting with contravention of the provisions of the Drugs and Cosmetics Act. Clause 7.8 deals with contravention of the provisions of the Drugs and Cosmetics Act. It states, a registered medical practitioner shall not contravene the provisions of the Drugs and Cosmetics Act and regulations made thereunder. Accordingly, a. prescribing steroids or psychotropic drugs when there is no absolute medical indication, and b. selling Schedule H and L drugs and poisons to the public except to his patient. In contravention of the above provisions shall constitute gross professional misconduct on the part of the physician. Next comes performing or enabling to perform abortion or illegal operation. Clause 7.9 deals with this sort of misconduct. It states, if a doctor is performing or enabling unqualified person to perform an abortion or any illegal operation for which there is no medical, surgical or psychological indication, he shall be guilty of misconduct under this clause. Next comes issuing of certificates of efficiency. Clause 7.10 deals with any misconduct related to issuing of certificates of efficiency. It states that a registered medical practitioner shall not issue certificates of efficiency in modern medicine to unqualified or non-medical person. However, it does not restrict the proper training and instruction of bona fide students, midwives, dispensers, surgical attendants, or skilled mechanical and technical assistants and therapy assistants under the personal supervision of physicians. Next comes misconduct related to contribution to lay press articles and personal interviews. Clause 7.11 deals with all such misconducts. It states, a physician should not contribute to the lay press articles and give interviews regarding diseases and treatments which may have the effect of advertising himself or soliciting practices. However, he or she is open to write to the lay press under his own name on matters of public health, hygienic living, or to deliver public lectures, give talks on the TV or radio or internet chat for the same purpose, and send announcement of the same to lay press. Next, clause 7.12 deals with advertisement of institutions run by physicians. The clause states, an institution run by a physician for a particular purpose, such as a maternity home, nursing home, private hospital, rehabilitation center, or any type of training institution, may be advertised in the lay press, but such advertisement should not contain anything more than the name of the institution, type of patients admitted, type of training and other facilities offered, and the fees. Next comes restriction on use of signboards. Clause 7.13 deals with restrictions on use of signboards. It states, it is improper for a physician to use an unusually large signboard and write on it anything other than his name, qualifications obtained from a university or a statutory body, titles and name of his specialty, registration number including the name of the state medical council under which registered. The same should be the contents of his prescription papers. It is improper to affix a signboard on a chemist's shop or in places where he does not reside or work. Next comes misconduct with respect to confidentiality of patient information. Clause 7.14 deals with the confidentiality of patient information. The registered medical practitioner shall not disclose the secrets of a patient that have been learned in the exercise of his or her professional, except under the following circumstances. 1. In a court of law under orders of the presiding judge. 2. In circumstances where there is a serious and identified risk to a specific person and or a community. And lastly, 3. In case of any notifiable diseases. In case of communicable or notifiable diseases, concerned public health authorities should be informed immediately. Next comes non-refusal on religious grounds. So clause 7.15 deals with the non-refusal on religious grounds. It states, the registered medical practitioner shall not refuse on religious grounds alone to give assistance in or conduct of sterility, birth control, circumcision and medical termination of pregnancy when there is medical indication, unless the medical practitioner feels himself or herself incompetent to do so. Clause 7.16 deals with obtaining of consent before performing of an operation. It states, before performing an operation, the physician should obtain in writing the consent from the husband or wife, parent or guardian in the case of minor, or the patient himself as the case may be. In an operation which may result in sterility, the consent of both husband and wife is needed. Next, clause 7.17 deals with non-publication of case reports or photographs. It states, a registered medical practitioner shall not publish photographs or case reports of his or her patients without their permission in any medical or other journal in a manner by which their identity could be made out. If the identity is not to be disclosed, the consent is not needed. Next comes ultimate responsibility of a physician who is running a nursing home. So clause 7.18 deals with the ultimate responsibility of a physician in running a nursing home of his or her own. It states, in the case of running of a nursing home by a physician and employing assistants to help him or her, the ultimate responsibility always rests on the physician. Next is the use of touts or agents. Clause 7.19 clearly states that a physician shall not use touts or agents for procuring patients. Next comes misconduct with respect to claiming oneself as a specialist. So clause 7.20 or 7.20 states that a physician shall not claim to be specialist unless he has a special qualification in that branch. Next comes restrictions on in vitro fertilization or artificial insemination. Clause 7.21 deals with in vitro fertilization or artificial insemination. It states, no act of in vitro fertilization or artificial insemination shall be undertaken without the informed consent of the female patient and her spouse as well as the donor. Such consent shall be obtained in writing only after the patient is provided at her own level of comprehension with sufficient information about the purpose, methods, risks, inconveniences, disappointments of the procedure, and possible risks and hazards. Last comes restriction on research. Clause 7.22 deals with the restriction on research. It says, clinical drug trials or other research involving patients or volunteers as per the guidelines of ICMR can be undertaken, provided ethical considerations are borne in mind. Violation of existing ICMR guidelines in this regard shall constitute misconduct. Consent taken from the patient for trial of drug or therapy which is not as per the guidelines shall also be construed as misconduct. So with that, we have concluded our session on misconduct by physicians. Hope it will be useful for you, not only for your study purpose but for any practical purpose, given that so much gross violation of so many rules are going on in each and every sphere these days. In the next session, we will be discussing about something equally interesting and informative. Till then, thanks for watching.